Another day, another story. Section 64. Sentence of imprisonment for non-payment of fine. 3. In every case of an offense punishable with imprisonment as well as fine, in which the offender is sentenced to a fine, whether with or without imprisonment, and in every case of an offense punishable for, with imprisonment or fine, or, with fine only, in which the offender is sentenced to a fine. It shall be competent to the court which sentences such offender to direct by the sentence that, in default of payment of the fine, the offender shall suffer imprisonment for a certain term, which imprisonment shall be in excess of any other imprisonment to which he may have been sentenced or to which he may be liable under a commutation of a sentence. Section 65. Limit to imprisonment for non-payment of fine, when imprisonment and fine awardable. The term for which the court directs the offender to be imprisoned in default of payment of a fine shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for the offense, if the offense be punishable with imprisonment as well as fine. Section 66. Description of imprisonment for non-payment of fine. The imprisonment which the court imposes in default of payment of a fine may be of any description to which the offender might have been sentenced for the offense. Section 67. Imprisonment for non-payment of fine, when offense punishable with fine only. If the offense be punishable with fine only, 1. The imprisonment which the court imposes in default of payment of the fine shall be simple, and, the term for which the court directs the offender to be imprisoned, in default of payment of fine, shall not exceed the following scale, that is to say, for any term not exceeding 2 months when the amount of the fine shall not exceed 50 rupees, and for any term not exceeding 4 months when the amount shall not exceed 100 rupees, and for any term not exceeding 6 months in any other case. Section 68. Imprisonment to terminate on payment of fine. The imprisonment which is imposed in default of payment of a fine shall terminate whenever that fine is either paid or levied by process of law. Section 69. Termination of imprisonment on payment of proportional part of fine. If, before the expiration of the term of imprisonment fixed in default of payment, such a proportion of the fine be paid or levied that the term of imprisonment suffered in default of payment is not less than proportional to the part of the fine still unpaid, the imprisonment shall terminate. Illustration: A is sentenced to a fine of 100 rupees and to 4 months imprisonment in default of payment. Here, if 75 rupees of the fine be paid or levied before the expiration of 1 month of the imprisonment, A will be discharged as soon as the first month has expired. If 75 rupees be paid or levied at the time of the expiration of the first month, or at any later time while it continues in imprisonment, A will be immediately discharged. If 50 rupees of the fine be paid or levied before the expiration of 2 months of the imprisonment, A will be discharged as soon as the 2 months are completed. If 50 rupees be paid or levied at the time of the expiration of those 2 months, or at any later time while it continues in imprisonment, A will be immediately discharged. Section 70. Fine leviable within 6 years of during imprisonment. Death not to discharge property from liability. The fine, or any part thereof which remains unpaid, may be levied at any time within 6 years after the passing of the sentence, and if, under the sentence, the offender be liable to imprisonment for a longer period than 6 years, then at any time previous to the expiration of that period, and the death of the offender does not discharge from the liability any property which would, after his death, be legally liable for his debts. Section 71. Limit of punishment of offense made up of several offenses. Where anything which is an offense is made up of parts, any of which parts is itself an offense, the offender shall not be punished with the punishment of more than one of such his offenses, unless it be so expressly provided. 2. Where anything is an offense falling within 2 or more separate definitions of any law in force for the time being by which offenses are defined or punished, or where several acts, of which one or more than one would by itself or themselves constitute an offense, constitute, when combined, a different offense, the offender shall not be punished with a more severe punishment than the court which tries him could award for any one of such offenses. Illustrations: A gives Z 50 strokes with a stick. Here A may have committed the offense of voluntarily causing hurt to Z by the whole beating, and also by each of the blows which make up the whole beating. If A were liable to punishment for every blow, he might be imprisoned for 50 years, one for each blow. But he is liable only to one punishment for the whole beating. B. But, if, while A is beating Z, Y interferes, and A intentionally strikes Y, Here, as the blow given to Y is no part of the act whereby A voluntarily causes hurt to Z, A is liable to one punishment for voluntarily causing hurt to Z, and to another for the blow given to Y. Section 72. Punishment of person guilty of one of several offences, the judgment stating that it is doubtful of which, in all cases in which judgment is given that a person is guilty of one of several offences specified in the judgment, but that it is doubtful of which of these offences he is guilty, the offender shall be punished for the offence for which the lowest punishment is provided if the same punishment is not provided for all. Thanks for watching.